Your state was, by the way, Walker snorted a lot of marijuana. Okay, good. That's what you do. Yeah, his state recommended that some marijuana. Thank you.
So I'm very practiced at like talking to somebody over here, but and going back out with someone else. Yeah. And she didn't hear me, and she could hear.
She chaired me. Steve's excited about he's going to do.
Civil and criminal proceedings will now come to order. We're not, I first want to apologize because of Senator Vogel's funeral. We had to move our time. So we're going to try to do the House bill first, and if the senators, we need to come back this evening. I have no idea what time that's going to be given the schedule, but so we'll hear testimony on House Bill 2433.
Let's leave it on the table.
Thank you, members of the committee. Representative Galt for the record, 39th District. House Bill 2433 is the structure and compensation bill for prosecuting attorneys. Something that's been filed the last couple of years. Hasn't gone as far as we'd like, but we do have a situation in the state where we have part-time prosecuting attorneys. We have counties who they just don't have a lot of attorneys in their municipality. This is a way to try to set up a mechanism whereby we can increase the pay for the prosecuting attorney and set up a mechanism where counties can get together, smaller counties, especially in North Missouri, to elect a full-time prosecutor. This is a step up over time to pay these full-time prosecuting attorneys by 2027, a wage that we feel is online with the associate circuit judge in those counties. The bill also talks about local prosecuting attorneys representing the state and the mechanism whereby if a county wants to undo the provisions of creating a full-time prosecutor for another county, how that's paid for, and then how that process is undone. So if there are any questions, I'd be happy to answer those.
Any questions for the representative? Representative Corbett.
Thank you, Representative McGaugh, for bringing this bill. Seems like a needed bill and legislation. In terms of the compensation, does it step up to 50% of associates?
That's correct. So over time, it moves up slowly to allow these jurisdictions to basically budget for the increase.
And is that, in terms of that, then what percentage, if you have a situation where you have a prosecutor in joint county by county, what's the percentage paid for each county?
I believe that the mechanism is talked about in the within the legislation. I think we have individuals from the Prosecutor Association that can probably give you some more specific detail as to those numbers.
Okay. And is that, in terms of your legislation, is that just a minimum or a maximum, or what's the, as far as?
Right, that would be the minimum.
Okay, so the county can work it out, we're not tying the hands of the commissioners.
Yeah, I think a lot of times smaller counties have a salary commission whereby they can set different amounts.
Thank you.
Any other questions for the representative? Seeing none, anyone here to testify in favor of the bill?
My name is Bob McGaugh. I'm the prosecuting attorney in St. Louis County and the co-chair of the legislative committee for the Missouri Association of Prosecuting Attorneys. We're here in support of this bill. I won't repeat what the sponsor has already told you about that, but to add a couple things to that. What would require, this provides a mechanism for counties to band together. In some situations, they already do, in child support areas, for example. So counties that have part-time prosecutors are able to band together, if they so choose, to have a full-time prosecutor. If they do that, then that would have to be approved by the voters in each of those counties by 4/7 majority, so that one county couldn't necessarily dominate another county. Both counties would have to approve it by 4/7. That position would then become full-time. The prosecutor would represent that. Similar to the pay raise for the part-times I'll talk about in a second, the budget would be worked out among the county commissioners based upon the population, the caseload, the workload, and to work out all the details. Very similar to what they do currently in their own counties, but to band together, they have to be contiguous counties in the same circuit. So it could be up to 4 counties in some situations, but it could be as few as 2. Regarding the pay for the part-time prosecutors, that applies, first of all, only the part-time prosecutors, and it would be phased in over 12 years and take it up to 50% of whatever an associate circuit judge is making. Counties can go above that if they so choose, but they can't. They can go above that if they choose, but they can't get below it. So in 12 years, it would be up to 50% of an associate circuit judge. It has been, it was pointed out, that it's been 17 years since the last raise across the board in any event or even change in the system for raise for part-time prosecutors. So I think those are the key points. There is some written testimony being provided by the part-time prosecutors on behalf of the part-time prosecutors detailing the history of the pay and the structure and the mechanisms for payment on that. So with that, he said the Missouri prosecutors, full and part-time, and the entire association are in support of this bill, and yeah, we don't answer any questions anyone may have.
Any questions for the witness? Representative Gardner.
Thank you.
Proceed.
So this bill seems like it's more directed to part-time prosecutors, is that correct?
Correct. It's directed basically only to part-time prosecutors, but it allows counties to band together and have a full-time prosecutor for more than one county.
So give me an example in your experience of this, where this is an issue. I know that a lot of little municipalities have these part-time prosecutors in rural areas, and I know that may be an issue, but as you know, in the area you represent, your prosecutors have a high caseload and
Correct.
they get paid more. So I think that, in some of these small municipalities, they don't have the same caseload as the main cities like St. Louis City or St. Louis County. So can you tell me where the issue in terms of the part-time prosecutor, how this would help them as well as to me? I think that all prosecutors should get a raise, especially in the city and the county.
Well, I'm with you. That's a separate issue. The way it works now is we have some counties that have a part-time prosecutor, but they have a large enough population, a large enough population center where a great deal of their work is, or a great deal of their time is taken up. It's more than part-time. It's not a 20-hour-a-week job. In other counties, it may indeed be a 20-hour-a-week job or something less than that. But those prosecutors currently are paid based upon a system that was put in place decades ago, and it's wholly inadequate at this point. So what this bill would do is, if the county chooses to remain with a part-time prosecutor, then there'd be a pay raise built into that would take it up to half of what the associate judge makes. So this is up to the counties and the voters in those counties to make that determination as to whether they want to remain part-time or full-time, whether their caseload is such that they should go to full-time, whether they should band together with an adjoining county and have one full-time prosecutor with an adequate staff to cover both counties or
But they would still have to run, like they're still elected, they would still have to run.
Correct. The prosecutor would still be elected in the county if they remain part-time, or elected in the combined counties, however many there may be, if they combine, correct?
All right, thank you.
Any other questions for the witness? Representative Corbin,
Required.
proceed.
Thank you, Mr. McGaugh. Could you also just touch on the, or describe, there's a portion in debt collection, the part of the legislation?
Correct. There's a provision in the bill that would authorize the counties or the county prosecutor to collect debts that are due, costs that are due, whatever it happens to be, to different state agencies. Right now, we have that ability with the Department of Revenue on taxes, whether it's income tax or sales taxes. And so this would expand that to cover other state agencies where they could, in effect, contract with the county prosecutor in order to collect the outstanding debt, whether it's pick a department, I think covers all the departments on there. The arrangement is that the Department of Revenue is there's 20% of what's recovered goes to the back to the county and the county prosecutor. And there's a similar arrangement for other state agencies in the provision of the bill. A portion goes back to the prosecutor, and a portion goes to the technology aspect of statewide prosecution.
Would it also apply to county agencies?
Specifically, it doesn't apply to county agencies, but I think within the county and in some county, I only speak for St. Louis County, that we have a county counselor who handles debts that are owed to the county or city. As a city counselor, they are the civil attorney for the city. They do that. But I'm not aware of any provision that would prohibit that. I don't know if specifically authorized. We're also looking at collecting the court costs that are out there on behalf of the circuit courts.
Right now, is some of that debt collection done, do they contract with private attorneys?
We contract with private collection firms. Some are attorneys, I'm sure. Some are debt collectors. They have their arrangement with them that's similar to any other debt collector.
You see,
Significantly higher than 20%.
that was my follow-up question, is if there would be some efficiency gains to the state through this.
I think there is some. The Department of Revenue also uses, in some cases, private collection agencies. And if you just look at the numbers that, and obviously the 20% is significantly less than what they're charging. In all honesty, though, the dollar amount collected is significantly higher by us.
Thank you.
Representative Cornell, proceed.
So my question is just real, maybe better for the bill sponsor, I'm not sure, but just why the 4/7? I mean, I heard the argument of, you don't want one county with a little bit higher population, maybe crowd out the smaller county, but if you just did maybe the majority in both counties, that would still get to what you're trying to do. So I'm just wondering, is 4/7 like another statutes elsewhere, or?
I think that it was in statute.
Right.
Yeah. Another location.
I'm sorry, what?
It's in statute in another location. And I think we possibly have another witness call specifically on that.
Okay.
With the 4/7, it's just to have a supermajority, so there's any question but that the local voters are more than just half in favor of taking this action. There are other provisions in other statutes that allow or require a 4/7 vote, primarily on taxes that are out there. They have to be approved by 4/7 of the voters, a supermajority.
And just one quick follow-up question. Do the counties then call their own special election, or do they have to wait for the next primary general election?
You know, you got, I don't know at this point, you know. I think it's the next
10% to get on that way.
10% to get what?
Of the elected vote.
You take 10% within the bill, and I'm passing on the latest to 10% of the registered voters that get it on the ballot.
Called special election? Yeah. Okay, thank you.
Any other questions for the witness? Thank you, sir. Appreciate it. Anyone else here to testify in favor of the legislation?
There is some, it's just a written testimony that we'll provide on behalf of the part-time prosecutor specifically about the pay rate.
I'm Brian Keating. I'm the prosecuting attorney in Sullivan County, North Missouri. Previously, I was the prosecuting attorney in Camden County, so I've got kind of a unique situation where I was a full-time prosecutor for 6 years, and now I'm a part-time prosecutor. Just to give you some idea, in 1998, the part-time salary in Sullivan County was roughly half of what the full-time salary for the prosecutor. Full-timers were getting about $89,000 at the time. In Sullivan County, I think the salary was $41,000. Right now, the full-time prosecutors get $133,000. Part-time prosecutors get in Sullivan County $41,000. So there's been a 52% increase in the salary for full-time prosecutors in the past 17 years, and none for the part-time. So part of what we're trying to do is to correct this inequality. I provided in the written testimony just a spreadsheet that provides some information and facts about what that would mean as this gets phased in. And I think the numbers are still less with this pay raise than the 52% that full-timers are receiving. So it's less than what they were getting, but it's more than what they're getting.
Any questions for the witness? Representative Gardner,
Thank you. To inquire.
proceed.
So you said you were a full-time prosecutor where?
In Camden County, like the other,
Camden County. And what was your salary there?
133 rounded.
Now, what was your caseload? What was
So I had an office with 17 people, 4 assistants plus myself, and I can't tell you what the caseload was, other than it was a lot.
And what was your, you said you had 17 people, 4 assistants, so how many attorneys, 17 attorneys working under you?
Five attorneys, including me.
And what was their average pay?
70,000.
Now you're a part-time prosecutor in Sullivan. Okay, what is your pay now?
Well, I got bumped because we went up in assessed valuations. 43,000 was 41 last year.
And what is your, how many people you have under you?
1. Me and a secretary.
Okay.
And a telephone.
A computer? You get a computer?
We have 1 computer.
Well, you know, I appreciate, like I said, you know, I support prosecutors raising their salaries, but I think that in areas like St. Louis City, of course, St. Louis County, they get paid way more than the prosecutors in St. Louis City, which makes an average of $45,000. That's a pay increase when I was there. And I think that we look at caseload, we look at resources. I think that it's a big discrepancy that we need to look at the whole system of prosecutors. So appreciate your testimony.
Great. And I'm not working half the time, or even that percentage of the time. It does require more. I don't have people to cover for me on weekends. I'm on call 24/7. Not that I get called 24/7, but you know, I don't have the support staff. You were asking about other counties, other examples. The prosecutor in an adjoining county, Mercer County, has recently announced that he's resigning to become a assistant prosecutor in Christian County because the pay and the retirement are better. So there will be a vacancy there that will have to be filled. I don't know what's going to happen, but that would be one example of a county where we just aren't able to hang on to the prosecutors that they have. In my county, I got appointed by the governor when nobody filed for office, and there was a vacancy. So it's an opportunity for me to continue as a career prosecutor, which is what I want to do. So that's why I'm here.
Thank you. Any other questions for the witness? Seeing none, thank you, sir. Is there anyone else who needs to testify in favor? Anyone here to testify in opposition? Anyone here to testify for informational purposes? Seeing none, that'll close the hearing on 2433. Secretary, can you call the roll? Representative McGaugh. Here. Vescovo. Present. Colonna. Andrews. Corley. Cornell.
Present.
Gardner.
Here.
Hampton. Marshall.
Here.
McDaniel. Dayton.
Here.
White. One being established, we will begin our hearing, full hearing. We'll now go into executive session. I have a motion to pass House Bill 1993. Is there any discussion? I think there's an amendment, Representative Blaine.
Yes, I forgot my paperwork up in the office. I just now realized it. So I have an amendment ending in 03H that has been distributed. And last week, earlier this week, and all the committee membership have been given. This amendment was basically mocked up like a, so it was easier to read kind of what was going on. But this is something that we talked about during the hearing to address some of the concerns. Well, take input from anybody, and I think a lot of us can incorporate some of the concerns raised by that for the school board association, as well as other people want to see it. So, basically the sunshine bill, and a whole bunch of changes, diagnosis and things. For example, the original file bill increased 48 hours back up to that. Summary is available to summary minutes of closed meetings. It's pretty simple as what was originally filed. You know, again, this amendment incorporates a lot of the concerns people have, but again, ultimately, at the end of the day, you know, we're probably just going to have to make a policy decision. You know, the general concept is meetings are open, public, and we should bear the cost of that, you know, the public request. And this is that the general presumption is it's open and should be available to the public, but I also don't want somebody from the general public saying, well, I want 6 months of every single item that's done, and then I got to hire an attorney and come back and force through 6 months of whatever the request is, and just, you know, so again, trying to walk that fine line. Again, I think this amendment addresses all the other concerns, but again, we probably will just have to make a policy decision. Representative?
Thank you. So I understand that, is it the press is okay with the amendment? Where, do we know where the Muni League is? I think you said the school boards were okay.
Well, I don't want to put words in the school board, because again, I think ultimately, we're going to have to make that policy decision of who's going to have to bear this cost. And so I don't know if I will ever get them 100% on board.
Yeah.
But this amendment definitely addresses some of the other issues going on that were presented.
Okay. And do we know where Muni League is?
I don't know.
Seeing no other discussion, this amendment will be a voice vote. All those in favor, please say aye.
Aye.
All those opposed say no. Amendment passes. I renew my motion that we do pass House Bill 1993 as amended. Is there any discussion? Seeing none, Secretary, please call the roll. Representative McGaugh. Aye.
Vescovo.
Aye.
Colonna. Andrews.
Corley.
Aye.
Cornell.
Aye.
Gardner.
No.
Hampton. Marshall. McDaniel. Dayton.
I to continue it moving through the process.
White. Representative Marshall.
Aye.
By your vote of 7 yes, 1 no, you voted to pass House Bill 1993 as amended. Senator Wallingford. Apologize, I didn't see you sitting back there. We would have gone to executive session, but
So that's fine.
Good afternoon, distinguished chairman, honorable committee members. I'm State Senator Wayne Wallingford, representing the 27th district. I bring before you Senate Bill 618, detention of persons under the age of 17 in adult facilities. And this bill did pass out of the Senate 32-0. Study after study finds that youth and adult facilities face higher rates of suicide and abuse by other inmates. It's unacceptable to expose our children who one day return to our communities to such trauma. The trauma and exposure to adult criminals harms public safety outcomes. Youth have significantly higher recidivism rates when they are sent to adult systems compared to juvenile systems, and Missouri's model juvenile justice system is best suited to alleviate juvenile delinquency. Holding youth in adult jails pre-trials is especially problematic as the youth are exposed to the adult criminal system before they are being convicted. 20% of juveniles sent to the adult system do not receive an adult conviction, and 15% receive no conviction at all. We should not expose our children to adult jails pre-trial when 1 in 5 will not receive an adult conviction. The Prison Rape Elimination Act, or PREA, of 2003 puts grant money at risk if Missouri does not separate youth and adults in adult jails and prisons. States across the country found that removing youth from adult facilities is the most cost-effective way to comply with PREA. Missouri can and should come into compliance with PREA to protect our youth. Retrofitting all of our county jails, lockups, and prisons to meet this standard is too burdensome. Therefore, removing the youth from adult facilities makes fiscal sense. Additionally, holding youth in adult jails pretrial denies them the educational opportunities provided by Missouri's juvenile system at a pivotal moment in their development. Falling behind educationally at this critical juncture will hamper them throughout their adult life. Juveniles belong in the juvenile system. This is especially true when the children have not been convicted of a crime. There's plenty of space in our juvenile detention system to house youth charged with criminal offenses. Youth arrests have dropped significantly in Missouri. There are not more than a couple dozen youth certified as adults in Missouri, and there are hundreds of available beds. In 2013, there were approximately 23,000 arrests of juveniles, down from almost 50,000 juvenile arrests in 2006. The overwhelming majority of youth were arrested for misdemeanor offenses. Oregon, Virginia, and Colorado have seen the benefits of placing youth tried as adults in their juvenile system, and juvenile facilities meet the developmental needs of youth that offer age-appropriate education service, have staff members trained in adolescent development and cognitive behavioral skill building programs tailored to the youth. Children should be held accountable, but restored and rehabilitated. The Missouri Bar supports the concept of age-appropriate treatment for juvenile offenders. Incarcerating youth in adult jails and prisons is the most expensive option that consistently produces the worst results. It's time to switch from prison to programs. This bill also had 2 amendments, one for shackling of juveniles. I've done a lot of study on this, and I read an interesting article from a judge from the state of Texas who has the state has over 3,000 juvenile cases a year, and we only found the need to shackle 2 of those juveniles out of the 3,000 cases. They've never had a court disrupted at all because of that. In fact, the judge said the outcomes were actually better because the juveniles made eye contact, they were listening, and also juvenile experts and Psychology experts say these youth come to the court already traumatized, and this makes it worse. Also, an amendment was added for shackling of pregnant women. There's concerns that shackling restricts women's movement and increases pregnant women's likelihood of falling because of their centers of gravity offset. Falling can harm the fetus and their mother. Women must be free to move around while in labor to allow their bodies to naturally progress into delivery. The use of restraints during labor result in full groin muscles, separation of pubic bones, permanent hip injury, torn stomach muscles, damage to sciatic nerve, deformed hips, and inability to have any more children. Also, shackling pregnant mothers also puts onboard children at risk. And there was just an article that came out today, Southeast Missouri, about a mother who was shackled in Mississippi County, and it caused, she's alleged it caused the death of her baby. Now that is, she's filing a suit in federal court this week. Also, the majority of women incarcerated while pregnant are nonviolent offenders incarcerated for various crimes such as possession of narcotics or theft, and are classified under the lowest levels of flight risk and harm to others. No reports exist of any unshackled pregnant inmate trying to escape while in labor, even in states that have adopted anti-shackling laws. With that, that ends my testimony, and if there are no questions, I do have some witnesses.
Any questions for Bill sponsor? Representative. All right, so I guess my question is kind of focusing on the amendments that were added later on. So the juvenile shackling. There's a couple different versions floating around the building regarding juvenile shackling. Can you go more in depth into that one? Is this one that the local county judge gets to make the decision?
The defense attorney would petition the judge, and the judge would make the decision if the juvenile presents a flight risk or possibly harm to themselves or other people. And then if the judge says, no, I believe that shackling is ordered, then they would make a finding as such.
So the judge makes the whole.
The judge makes the decision.
He or she has all the correct. The shackling of pregnant women, if I'm reading it right, postpartum is only 48 hours?
Correct.
Unless extraordinary circumstances.
Yes. And the doctor would determine if there's extraordinary circumstances.
Thank you. Those are all the questions I have.
Representative. Thank you, Senator. I heard versions of this early on. One of the questions that I would have is, would this prohibit the use of leg locks?
The pregnant women you're talking about?
Yes, not the shackles, but the braces that are put on. Law enforcement have at their disposal that if the person takes off running, they just lock in place.
Well, on the pregnant women, they don't want waist shackles or leg shackles or ankle shackles.
It's a totally different type of mechanism. Thank you, Mr. Chair. Thank you, Senator.
Any other questions? Seeing none, anyone here testifying in favor?
Good afternoon. It's nice to see a few of you from Corrections this morning again. My name is Catherine Curbs. I am a 2L at the University of Missouri School of Law, and I helped to draft this language as it relates to pregnant inmates. You'll hear a little bit more from Missouri cases specifically, but I'd like to tell you about a federal court case that came out of Arkansas. In 2009, Shawnee Nelson gave birth to her daughter while she was incarcerated in the state prison facilities in Arkansas. She was shackled all through labor and delivery, and she, from that, she obtained a torn stomach muscle, umbilical hernia that required surgical repair, and a permanent hip injury. And she was instructed not to have any more children. The 8th Circuit Court, of which Missouri is a member, found that this treatment of shackling was cruel and unusual punishment and was in direct violation of the 8th Amendment of the Constitution of the United States. The corrections officers in the Arkansas case were acting under an administrative regulation that is similar to the current policy that Missouri has that requires the officers use good judgment and when using shackles and that they use them when circumstances require. But that regulation proved incapable of protecting Arkansas from civil liability, and I'm sure would be the same in Missouri. That's why we need this statute to protect the state from civil liability and to give the corrections officers a right line test, and that the practice is just banned in all circumstances unless the extraordinary circumstances are present, as is in the bill. And this, the 1983 claim that Shawn and Nelson brought was merely a reactionary measure. It didn't prevent the harm that Ms. Nelson suffered in the first place. And this bill would prevent the harm to a woman and her unborn child before she could be harmed.
Correct me if I'm wrong, but the doctor or the doctor, nurse, or other healthcare provider treating the pregnant offender, they have the discretion whether or not shackles shall be used. Is that correct?
They can ask for them to be removed. In Shawn and Nelson's case, they asked repeatedly for them to be removed, and they were not removed. The policy that is proposed, the statute that's proposed, would not shackle them unless there was some sort of extraordinary circumstance, and then that extraordinary circumstance would have to be documented and be kept available in case there were any lawsuits or any problems with the shackling that arose.
And you talked about the current regulation of the Department of Corrections. What is that current?
I do have it written somewhere, but basically, the current policy is to shackle at officer's discretion. The shackling does happen. Apparently, corrections experts, they don't.
Correct me if I'm wrong, I mean, shackling could happen if we pass this legislation.
Only in the most extraordinary of circumstances.
Right, but it could
correct.
So now it can happen,
And
but you don't know that it is happening all the time.
I do know that it's happening, and the statute would prevent it from happening.
What are the cases that? it's happening?
Another person will offer testimony about.
Because the two cases that the senator brought up, those inmates were in county facilities.
Yes, that's correct.
We're
We
talking
have
about
the
Department of
Missouri
Corrections.
Department of Corrections. Yes.
Any other questions for the witness? Representative Quinn?
Okay, so as I'm reading into that section a little more, I guess I was confused off the bat. So the doctor is making the determination whether extraordinary circumstances exist to shackle, put the shackles on.
That is not my understanding. My understanding is that the extraordinary circumstances are determined by the corrections officer, such as if the inmate is a danger to herself or others or poses a flight risk.
Well, that's current law.
No.
Representative, on page 8,
Yeah, down the bottom.
section 217.151, it says, for the purpose of this section, extraordinary circumstances exist when a doctor treating the pregnant or postpartum offender makes an individualized determination that restraints are necessary.
So correct. So this bill's leaving up to the, so what kind of extraordinary circumstances do you think a doctor would say, yeah, this person needs to be restrained?
If the doctor fears that the woman is going to injure him or her staff, she's trying to escape. There are no documented cases of anyone trying to escape, but
Do you think a doctor is in a better place to determine that rather than correctional officers that are dealing with
no,
flight risk and everybody every day?
Was it?
Representative Garth?
Yes, inquired. I'm happy to hear parts of this bill in corrections. So I've heard some of the witness testimony. Right now, currently in Missouri, is it correct that there is discretion by the corrections officer? And this policy to put in place is about safety, so we can declare when you can and cannot shackle a pregnant woman. Is that correct?
Yeah, the policy makes the presumption that you don't shackle. So now it's just wide officer discretion, but the statute creates the stance that shackling is not allowed unless the circumstances are present in which it would be necessary.
And this bill is not taking away that discretion.
No.
It's just clarifying how, when we use that discretion, so a healthcare provider, less correctional officer, who would have more interaction at the time of the woman going to labor, at that time, kind of have guidance on what they can and can't do in those very limited instances.
Correct. It provides the oversight and the accountability that would be necessary to keep women and their children safe. And while at the same time protecting doctors or corrections officers if a person does pose a risk.
And as we all know, I mean, I'm one of the rare women being represented. We have had children, and we do know that a pregnant woman is not going to run.
You're busy with
Going to give
that.
birth.
There's
And I can
actually,
attest to that in my personal experience. It's not a flight risk unless there's some super uneven person, you know, after they deliver, they're in pain. Their bodies went through a lot of trauma, even though it's a blessing. But we know that this is something that can be done. There's no documentation because, of course, you know, the Department of Correction can be sued if they document that they did shackle when something happened. So I thank you for this policy.
Any other questions for the witness? Thank you for being here. It's not too late for you, 2 hours. Do we have any other individuals out of town that want to testify on this bill? Out of town folks? We're running short on time, so I'm going to take out of town folks first. In favor? Ma'am, in favor?
Yes.
Okay.
Good afternoon, Representatives. My name is Allison Drees. I'm the Executive Director of NARAL Pro-Choice Missouri. Because there's a lot of people in the room today, I'll leave it short for you, but just, and I have written testimony I can read for you. I think there are a lot of qualified people in this room that are going to give you Missouri specific stories and statistics that will really support this legislation. But we're just here to testify in favor and let you know as far as shackling of pregnant women is concerned. This bill, Senate Bill 618, was amended to include Senate Bill 977 from Senator Jamila Nasheed, which already heard testimony in committee and was passed out at that time. And there's some people in the room here today. Senator Eric Schmidt mentioned that this was the first time pro-choice and anti-choice groups had ever testified on the same bill together, and those same people are here today. So we'd just like to point that out and say that we support this bill and hope that we see more policy that supports women and families in this matter. Thank you.
Any questions for the witness? Seeing none, thank you, ma'am. Anyone else to testify in favor?
Good afternoon. My name is Brittany Flegger. I am Catherine Kerr's colleague as a 2L at the University of Missouri. And I'm here, I kind of want to address a couple of questions. I know the current policy has been a little bit up for questioning. So I kind of wanted to talk a little bit about that briefly. The current policy is up to officer discretion during transportation. But they are required to carry a full set of restraints. And because it is up to officer discretion, that is something that they can do. However, the policy as far as once the inmate is arrived at the hospital is that they will restrain them to the bed, one arm or one wrist and one leg to the bed, and that's the policy currently. We have a testimonial that you guys have written. It's from a third law student that's been working on the research with us, but she cannot be here today because she has a presentation. And she interviewed a woman who had given birth in the State Department of Corrections care in 2014. For all intents and purposes, we call her Beth. She did not want to give her name. And basically what happened was she went into labor. They transported her to the hospital from Vandalia in wrist shackles, leg shackles, a waist shackle with a box that connected all three on her pregnant stomach to the hospital. When she was at the hospital, they shackled her one arm, one leg to the bed as per policy until she was ready to deliver. She delivered and immediately put the shackles back on. She was out of the hospital in 24 hours. So that's the Missouri story that I'm going to share with you. Just to give you some statistics, Missouri specifically, 168 women are pregnant in Missouri system in 2015. 64 babies were born to these women. And of these 168 women, 91% are nonviolent or drug offenders. 95% of these women are low risk or medium risk, and with the majority of these women being low risk inmates. This proposed bill also reflects the federal government as well as 21 other states that have similar policies in place. These range across party lines. There's Florida, Texas, and Arizona that have approved these bills along with states like New York and California. And finally, several organizations have also adopted proposals against the shackling of pregnant inmates, including the American Congress of Obstetricians and Gynecologists, the American Medical Association, the World Health Organization, and the American Correctional Health Services Association. The shackling of pregnant women is not effective justice, and we need to change this Missouri practice to reflect a more constitutional and safe environment for our pregnant inmates.
What was Beth charged with?
She was, I don't 100% know, it was some kind of drug offense. She was in for a 120-day shock treatment in Vandalia.
I guess this can go to either year of the Senate. There's no exemptions for prior violent people, felons of murder, assaults, rapes, something like that in this bill for these pregnant people at all.
No, so that would fall if if it was thought the extraordinary circumstances would cover that. If it was considered to be a present danger to the doctor or the officer who's in the room at the time of labor, then.
I guess my question goes to the actual field for being a pregnant lady being shackled. It's going to get the doctor and not the corrections officers.
It's been a while since I've looked at the language.
There's been violence consistently, and the corrections officers seeing them do their 120s for whatever assault seconds, constantly assault seconds. Women do the same crimes as men. So they do have to. That's my question on that part.
Right, and I'm not sure to answer your question. I will say that there are, of the 168 women, I can tell you 11 of those women are in for a violent offense.
Represented.
Chair Power, briefly.
Yes.
Thank you. The way that I understand the language, and you tell me if this was your intent, sponsor, please feel free to jump in, is that basically it sounds to me like the corrections facility has to convince the medical staff that there's a problem. So if you have someone that's in there for a violent offense, a murder or whatever, and they've been a problem for them, then it would be the corrections facility the corrections staff has the opportunity to talk to the doctor and say, Doc, this is one we think you should shackle. But they have to basically convince the doc that it's appropriate and that it's not going to create some medical issue. Is that a fair assessment?
That is a fair assessment.
And you agree?
Yes.
Thank you, Mr. Chair.
And just to clarify the language, in the bill, it says for purposes of this section, extraordinary circumstances exist when a doctor treating a pregnant or postpartum offender makes an individualized determination that restraints are necessary to prevent a pregnant or postpartum offender from escaping or seriously injuring herself, medical or correctional personnel, or all others. So I think this bill actually brings everyone to the table to make a determination, and one is not trumping the other, but they make it together for the health and safety of the woman, as well as the personnel, as well as the baby. Is that correct?
Correct.
Thank you.
Seeing no other questions, thank you.
Thank you.
Next in favor.
Thank you, Mr. Chairman, members of the committee. Samuel Lee with Campaign Life Missouri to go on record in support of the portion of the bill dealing with the shackling of pregnant and postpartum offenders. I'll be testified in favor of it. Just to slightly correct my colleague with NARAL, Senator Eric Schmidt would never use the term anti-choice. He did refer to pro-life and pro-choice groups testifying together in favor of this bill. As I read this bill, I was not involved in any drafting, but as I read this bill, this is limited to offenders within the Department of Corrections. It does not affect those who are in your county or local jails. And I think it gives pretty strong authority to physicians and to other healthcare providers who are personally treating the women to make these decisions. And then from an opinion, as I read this bill, I don't think that leg shackles would be allowed. Because I'm looking on page 9, line 19 through 20. In no case shall leg or waist restraints be used on any pregnant or postpartum offender. As I read that, I think it would not allow that, but the restrictions would be on, question would be on
Sure,
arms and
wrists are basically shackles. The leg locks are just like a brace that you wear on your knee, and they just lock so that you have to walk stiff-legged. And I was hoping that the definition of those would allow a little bit more leniency to those officers that may find themselves in a circumstance that it really doesn't serve any purpose to bind the person's legs together that actually needs those freedom to give birth.
Right.
Okay. So if you have hand walking, it was very scary to watch those individuals walk. They have been used on homicide suspects that the court ordered to be able to come in through cities and not be shackled, and they use these leg snaps to prohibit them from running. So they're different than the shackling. So I have to do a little bit more research, but maybe some of our law enforcement friends can help us with that.
I don't read in the bill a definition of shackles, so I'm not able to answer the question, but.
Yes, sir. Thank you for testifying. And normally we agree on things. Could you tell me what specifically about the section on bottom of page 8 and 9, dealing with the shackling of pregnant women? Specifically, why are you in favor of that?
Well, why are we in favor? Well, to protect both mother and her unborn child. Okay, we think that there are that she and her unborn child are probably at risk in general for being in jail for whatever reason. I'm not talking about who's playing, but just saying in general would be at risk for health. But this
would be in favor then of not incarcerating pregnant women.
No. But this by having shackling would exacerbate any problems. Her center of gravity is different during pregnancy, and by having particularly wrist shackles, but also your leg shackles, can cause her not only to fall, but also to not protect herself or her unborn child. Particularly to have shackling during labor can cause blood flow problems to the unborn child. It can definitely affect labor and delivery, and would be, cutting off blood flow and oxygen could have a lifetime effects for mother and unborn child. So we think this is a reasonable approach. I think it's a good first step. Other states that have looked at this have been more comprehensive. I think this is a good first step for Missouri.
I hate to have you understand during trials. All right. Getting back to the question.
Yes, I'm sorry.
Do you see anything in this bill specifically that deals with unborn children? Do you see those words in here? Do you see the word fetus in here? Do you see the word child, unborn child?
No, the words fetus or unborn child are not in
So
there.
you agree that this amendment is not directed towards any type of special consideration for an unborn child?
I would disagree with that. Whenever you're dealing with pregnant women,
and the reason I use the word directly is that's an intentional word. Directly deals with that.
I would still disagree.
Okay. The words aren't found in here, but it still deals directly with it.
Yes, it does.
Okay. And you rightly pointed out that this section specifically says that in no case shall leg restraints be used on any pregnant or postpartum offender.
Correct.
That's never. That's even under extraordinary circumstances.
That's how I read it, but I know others interpret it differently.
Right. And so, as I understand it, that when it says on the page on page 9 at the top, on line 9, that no restraints of any kind be used, it means no restraints. And the restraints isn't defined in the amendment, is it?
No, the term restraints and shackles, I do not see that defined here.
So a court, when interpreting this, is going to say, we're going to use our common understanding of the word restraints. In other words, can't use handcuffs, can't do any type of restraining whatsoever if someone's in 6 out of their 9 months of pregnancy.
Except for extraordinary circumstances.
Right. And there's no exception whatsoever in here that I see for violent offenders.
I don't see it, no.
Okay. What type of medical evidence have you reviewed prior to testifying here today?
What I've seen online through various OBGYN organizations, nursing organizations, those who treat pregnant women.
Have you specifically consulted with a doctor?
I have not, no.
Prior to testifying? Thank you.
Committee will go into recess. We will re-adjourn upon judiciary hearing in the same room.
Mr. Chairman, do I need to come back?
Yes, sir.
Okay.
Yes, thanks.
Continue this.